Now, the Integrity in Public Life Act number 18 of 2013 was passed on the 9th of September 2013. It became operational in the Federation on the 11th of July, 2018. The main purposes of the Act are to make provision for a code of conduct and declarations of interest for public officials, to establish the Integrity Commission, its powers and its functions, and to provide for related or incidental matters. Now, if you look at the little booklet or leaflet, that you have been provided, you will find on the second page a list of all the persons and the offices to whom the Integrity in Public Life Act will apply. And just to mention some of the persons to whom it will apply: ministers of government, the Speaker of the National Assembly, and then heads of diplomatic missions, parliamentary secretaries, permanent secretaries, assistant secretaries, heads of department, Solicitor General and legal officers above the scale of K40, chairpersons and board members of statutory bodies. And then we have the Director of Audit, managers and directors of majority-owned, state-owned or controlled banks and other financial institutions. So those are the persons to whom the Act will apply. Now, the Act will also apply to spouses, agents, and in certain cases, children of public officials. Right? What the Act is really requiring public officials to do is, pursuant to Section 5 of the Act, to file with the Integrity Commission a declaration of all his or her income, assets, liabilities, and private legal or equitable interest in property. Now, for the purposes of the Act, property means land and any interest in land, money, stocks, bonds, shares, movable and immovable property, corporeal and incorporeal things having economic value, which are situated in St. Kitts and Nevis or elsewhere. So that if you have an interest in a property in Antigua or the U.S. Virgin Islands or in the United States, whether you own it outright or that interest is held jointly with another person, you will be required to declare that interest, that property, to the Integrity Commission. The Act also provides that public officials should declare gifts in cash or in kind received by himself or herself, his or her spouse, or his or her dependent children, so that if, for instance, you might decide you will go on a business trip on behalf of the government. You travel for government business, and while on the trip, someone gives you something, maybe a watch, or they try to give you a watch, but you're given a gift, whatever the gift is. You are supposed to declare it. We're not talking about, we're not really getting into the gift that you might be given at Christmas by your spouse, but anything that you're given of that nature, that is, you would need to declare it. Yes, you would need to declare it. In our review of the Act also, what we noted is that the Act had no limitation on what you should disclose. For instance, the present draft of the Act that has been enacted basically will mean that you will have to disclose, for instance, your expensive diamond ring that you may have gotten when you got engaged. For instance, you might have an expensive piece of property that is not like land or a house, like maybe an expensive painting, like an expensive chandelier that might cost over $50,000. Those are things that you would have to, based on the present draft of the Act, that you would have to declare. So it's not just property as in house and land, but anything that you have that of a certain value, and the value is to be determined, still to be determined, you will have to disclose it. Now, one of the things that the Act permits is for a public official to place his or her assets in what is called a blind trust. A blind trust refers to a financial arrangement in which a person in public office gives the administration of his or her private business affairs to an independent person in order to avoid conflicts of interest. It's called a trust, and the persons who overlook your affairs are called trustees. Under a blind trust, the owner of the property does not know how the assets are managed, nor does he or she have a right to intervene in their handling. The trustee has a full discretion over the assets. So what basically happens is that you put your property in a trust, and trustees are appointed, and those trustees manage it for you. But you do not get involved in the day-to-day management of the property, and you don't give directions in relation to the property. Now, the legislation says that where the assets are placed in a blind trust, only the amount and description of the assets need to be stated. Now, declarations are to be filed with the Commission annually, and Section 8 of the Act provides that the Integrity Commission shall examine every declaration that is furnished to it and may request from the person in public life any information, explanation, or further particulars in relation to the declaration, and may require the public official to attend before the Commission and to be heard on the matter of the declaration, meaning you make your declaration, and if something is unclear or there is some question the Commission need to ask you about, they can call you before the Commission and you can be asked certain questions. Of course, when you are going before the Commission, if you're called to go before the Commission, you're entitled to have a lawyer present with you. Where the Commission is satisfied that the declaration has been fully made, the Commission will issue a certificate indicating that the declaration has been made and that the public officer has satisfied the requirements of the Act. This certificate is normally published in the Gazette. The signed declaration made by a public official would only be made available for inspection where the Commission is of the opinion that it is in the public interest to do so. By this, what am I saying? For instance, if you make your declaration and it is before the Commission, no member of the public, no government official has a right to come and just request your declaration and just look at it. That is not what the Act allows or permits. So a person off the street cannot come to the Commission and say, I would like to see the declaration for Simone Bullen. They will not be able to do that. The Commission will only be authorized to allow your declaration to be viewed by someone if it is in the opinion that it is in the public interest to do that. Speaking from my point of view, I would suggest that might be, for instance, if there is an ongoing investigation. That would be one example where there is an ongoing investigation into you or into some activity that you may have been involved in, and your declaration might be deemed relevant to the investigation. That is one example that I can think of. So this is not a case where you make a declaration and it becomes public knowledge to everyone. It will only be made available if the public interest so requires. And of course, the public interest don't necessarily require that it be made available to the public at large. So it may only be made available in limited settings. Now, Section 30 of the Act makes it a criminal offense if you fail to make a declaration. Failure to make a declaration is a criminal offense. The penalty is a fine of $30,000 and/or 5 years imprisonment. In addition to the imposition of a fine and a period of imprisonment, please note also that the court can also order that you forfeit property that you have not disclosed to the state. So therefore, if in filing your declarations you have omitted to list the property that you own at Wade's Garden, the court can order that that property be forfeited to the government of St. Kitts and Nevis. If you have if you have already sold the property that you did not declare, or the property is out of the reach of the court, for instance, in Miami, the court can order you to pay the value of that property to the government of St. Kitts and Nevis. So failure to make a declaration is a criminal offense, and for the punishment, as you would recognize, it's quite severe. Now, apart from the declaration of assets, the Integrity and Public Life Act also provides a code of conduct which all public officials are required to sign. The provisions of the code are very similar to the provisions of the present regulations that are attached to the Public Service Act. Some of you who are familiar with it, when I'm speaking of the Public Service Code of Ethics, the Code of Ethics outlined in the Code of Ethics for the Public Service is very similar to the Code of Conduct that is outlined in the Integrity and Public Life Act. We have summarized and provided for you at the back of the leaflet some of the principles of the Code of Conduct, but please, this is just a small aspect of it. It's a couple of quite a couple of pages, and it covers a lot of material. Now, the Code of Conduct outlines how a public official is expected to conduct his or herself in the execution of his or her duties. In addition to the matters outlined on the leaflet, some of the matters that it covers are matters such as conflicts of interest, reactions to improper offers, for instance, how a public officer should behave if someone tries to bribe you or offer you a gift or ask you to do something improper. It also speaks to how you should behave in terms of involvement in political and public activity outside of public activity, and it also deals with access to information held by public authorities. Now, the Act creates two offenses that are basically targeted at the behavior of public servants. Those offenses are the abuse of office, that is one offense, and the second offense is misconduct and neglect of duty. I would advise, there's not enough time now at this meeting for us to go through all of those elements of those offenses and what would trigger those offenses. But for the offenses of abuse of office and misconduct and neglect of duty, I would suggest that you read it and look at it. In another meeting, we should be able to go through in specific details what those entails and how they would impact the behavior of public servants, or how they should impact the behavior of public servants. But for the purposes of this meeting, I would just say that there are two offenses targeted at behavior or conduct of public servants. In the case of the offense of abuse of office, the penalty, if you are convicted of such an offense, is $30,000, a fine of $30,000, and or imprisonment for 5 years. And in the case of misconduct and neglect of duty, the penalty, if convicted, is a maximum fine of $20,000 and or imprisonment for a period of 2 years. Now, the last item I wish to speak on is just a little bit about the Integrity Commission, because it follows that all public servants would want to know, I'm being asked to declare my assets, my income, I'm putting all my, so to speak, my business out there, my personal business out there. Who is it going to, and what are the powers and responsibilities of the Integrity Commission? So let us begin from this point. The Integrity Commission is a commission comprising of 3 members, whose members are appointed by the Governor General. in relation to the chairperson of the commission, that person is required to be a retired judge or an attorney at law with at least 15 years standing. That person, that is the chairperson, is appointed by the Governor General in his own deliberate judgment. The two other members of the commission are appointed by the Governor General on the recommendation of the Prime Minister and the Leader of the Opposition, respectively. Now, a member of the commission, once appointed, serves for a period not exceeding 5 years. Now, in terms of qualifications, what the Act states very clearly are the persons who are disqualified from being members of the commission. Automatically, all public servants are disqualified as members. So if you hold an office in the public service, or you're a public official within the definition of the Act, maybe you don't hold a position such as a PS or a PS or Solicitor General, Assistant Secretary, but you are a member of a statutory body, a state-owned, on the board of a state-owned bank, you would not qualify to be a member of the commission. Similarly, if you have been in public office, a holder of a public office, and you have, within the last 3 years, you would not be eligible for appointment as a member of the commission. And also, if you have been you're a holder of an office in a political party, that seems a little, I think we need to get some more definition to that. But if you have been held office in a political party 5 years preceding the date of the appointment, you would be ineligible. So the Act seems to exclude persons who have been in public service for a certain period, persons who are in public service, and persons who have political affiliations from appointment to the commission. Now, the functions of the commission, as outlined in Section 18 of the Act, include receiving, examining, and retaining the declarations, inquiring into the accuracy of declarations, and investigating allegations of bribery and corruption. The investigatory powers of the Commission are set out in Part 4 of the Act. Section 22 provides that in performance of its powers, the Commission shall have the rights to the same rights, powers, and privileges as that of the High Court. These rights include rights to compel witnesses to attend and the power to demand documents. So, for instance, if the Commission has a hearing and they have issued a direction that you should come, they can actually make you come, as in compel you to come. Section 23 provides that the Commission may inquire into the accuracy of a declaration if it considers expedient to do so, provided that no inquiry shall be commenced after a period of 5 years after the person has ceased to be a public official. So when you leave public office, for instance, you might be an assistant secretary and you retire, that is not the end of the matter. The Commission still has jurisdiction over you for a 5 years, period of 5 years after you have left. So so even when you leave public office, that's not the end of the matter. So you don't think you're severing all ties and you don't need to look back, depending on what is happening with you. Now, Section 24 outlines the powers of investigators, which include the powers of investigators pursuant to the Act includes entering premises used or occupied by a public official for the purpose of searching for documents and inspecting and taking away documents. Section 25 of the Act also provides that where an investigator has reasonable cause to believe that a public official is in possession of property disproportionate to his or her sources of income or assets, and there is no reasonable explanation for same, the Commission shall report the matter to the Director of Public Prosecutions for further action. So if you have disproportionate assets to your income, meaning your assets, you have $1 million in assets, but you only earn $2,500, and you have no explanation, for instance, that you inherited it from your father, that you had lottery, that you won the lottery and bought the expensive property, the Commission can look at that and they can report you to the Director of Public Prosecutions. The Director of Public Prosecutions, having received that report from the Commission, will then look at the matter, and if he has reasonable grounds to believe that an investigation into the assets and income of the public official is necessary, he will then apply to a judge for the issuing of an investigation direction. So if you look at the Act, and you read the provisions, what you understand is just not, the Commission just can't decide in terms of investigating you and looking at your assets and all of that. It's not just the Commission looking at it and then deciding we're going to go against this person. There are layers of review that will take place. The Commission will look at it first. If the Commission thinks that something looks wrong, the assets are disproportionate to the income, then the Commission can, if you have not provided an explanation, they can send it on to the DPP. The DPP will look at it then and see whether there is a case to mount an investigation. Then it goes before the judge, and the judge will decide whether there will in fact be an investigation. So that mechanism provides some layers of protection, in the sense that it's not just three people sitting in a room deciding your fate. It will start with the Commission. It will then go to the Director of Public Prosecutions, and then the judge will look at it and determine if an investigation should really be conducted into the matter. So there are some levels of protection within the system that would assist. Now, if the judge decides that there should be an investigation direction will be issued by the judge. The investigation direction must be in writing, and it must state the identity of the official being investigated and the period for which the investigation direction is issued. So it's not ad infinitum. They will issue a time frame within which the investigation is conducted. Of course, I'm sure that the Commission will be able to go and ask for, the DPP, will be able to go and ask for an extension if it is necessary. Now, if there is an investigation ongoing into you or into someone else that you may be affiliated with or no, if you attempt to or in any way hinder or obstruct the investigation or give false information in relation to the investigation, you will be committing an offense for which you're liable, if convicted, to a period of a fine of $10,000 or a period of 1 year imprisonment. I know in listening to the presentation, persons may think that it is onerous, but what I just want to re-emphasize is that in the Act, there are layers of protections that can be afforded to persons who fall under the Act. We always recognize that we live in a country where there are laws, even outside of the framework of the integrity in public life, which guarantees us as citizens of St. Kitts and Nevis certain rights and protections. So that if, for instance, you feel that there is something going on with the procedures that you don't like or is not fair to you, you can always take that matter to the court. So it's not a case where, it's being thrown on you, you have to do it, and you have no recourse if something you feel that you have in any way been treated unfairly. The provisions of the legislation in the framework of the Act itself and your constitutional rights would guarantee you some access to the courts for redress in the event that there is anything that is done that is unfair to you or that is in breach of your rights. Now, as I said, the Act itself provides a layer of protections in terms of the procedures required, in the sense that it's not just three persons, the commission themselves, who will make these decisions. If it gets to the point, or a matter is set to get to the point where there is a need for an investigation, the matter will go from the commission, then it will go to the Director of Public Prosecutions, and it will go to the court before an investigation against you will even commence formally, where you have to get involved. So there are measures that are there to protect the public servants. I also want to emphasize one of the things in our chambers that we have been doing is that we have been involved in it's an organization from the organization of the OAS, the American States, where they look at matters involving corruption. And one of the requirements that the Organization of American States put on countries, and I think the Commonwealth itself put on countries, is that you have an obligation to put mechanisms in place to ensure that you are complying with international standards as it relates to corruption and as it relates to good governance. This integrity in public life, whether you call it integrity in public life or you call it by another name, this is one of the things that the international community require of governments, that you have in your country a framework for declaring the assets of public officers. So what we're doing is nothing that is really new. It is, I think, two of the most active in commissions that we have are in Trinidad and Grenada. So what we're doing is part of our international obligations. We're seeking to comply with our international obligations. And of course, good governance is a tenet of the Constitution, transparency, good governance, accountability. So that is what this act seeks to do. I believe that what I've done is to outline some of the provisions of the Act. I would encourage you to read it. I believe that following this meeting, the Act itself will be posted on the SKNIS website, and there will also be copies made available to the permanent secretaries. I would advise and encourage that you read it. I thank you for listening, and I look forward to lively discussions.
Stay up to date with news, programs, and activities of the government with SKNIS. Like us on Facebook. Listen to us on SoundCloud. Follow us on Twitter. And watch our videos on YouTube. Connect with us today. SKNIS, St. Kitts and Nevis Information Service.